This is Duke University.
Welcome everyone to the Federalist Society's latest stop in our Lunch and Lecture series. Today we're going to be discussing the Patient Protection and Affordable Care Act with Dr. Michael Dreddy from the American Enterprise Institute, one of America's leading experts on federalism, and Professor Siegel, who needs no introduction himself. With that, let's begin as we go through our talk. Keep questions in mind. There will be 15 minutes at the end for questions and answers, so your participation is encouraged. Dr. Dreddy?
Thanks so much. Thanks to all of you for attending today. Thanks to Neil Siegel for participating in this debate. In light of the time constraints, both of us talk at breakneck speed and bother with all courtesies and not even pretend to respond to each other. There are four pieces of the Patient Protection Act that I want to talk briefly about, and they're all interlinked. The first part is, and the core of the statute in many ways, are the minimum coverage provisions that insurance companies have to satisfy. They can't exclude people on the basis of pre-existing conditions and so on and so forth. There's a lot of other stuff. These provisions turn health insurance into a product that can no longer be sold in private markets, at least not without massive subsidies, and then the Act would do the opposite of what it's supposed to do, namely reduce insurance coverage. To stem that, there are three parts to this statute. The first one is a gargantuan expansion of the federal Medicaid program. The second one consists of state exchanges, so-called state exchanges, through which private individuals can purchase subsidized insurance coverage. I'll come back to those exchange provisions. And the third one is, if the subsidies aren't enough to sustain private insurance, you've got to compel people to purchase the stuff. And so the Act contains a mandate, a purchasing mandate for certain individuals who don't otherwise have insurance, and it contains a mandate for business. In order to sort of comprehend how this fits together with federal power and the logic of our federalism, I want to make a distinction between the breadth of the federal government's powers and the depth of the federal government's powers. I borrow this distinction from James Madison, who called the federal powers federal in their extent. By what he meant by that is they're limited and enumerated in nature. There has to be a limit to federal powers. This is the question in the pending mandate litigation for which the cert petitions are now pending, or the main question. The depth of the national government's powers has to do with the question, well, suppose or granted that the federal government may it do X in any way, shape, or form it chooses. And there Madison says, no, the federal government's powers are national in operation. That is to say, they operate directly on individuals without the intermediation of the states. That question implicates the exchanges, Medicaid statute. And the case I want to talk about that is sort of the major case on this issue, near and dear to Neil Siegel's heart, is Prince versus United States. That case, in an opinion by, the majority opinion there is written by Justice Scalia. It's a 5-4 decision, and it says in a case dealing with certain federal gun registration requirements, the federal government may not commandeer state officers to execute federal commands. Why is that? Well, it's sometimes said the Madisonian provision, the federal government's powers are national in operation, means that the federal government can't act on states, it can only act on individuals. That's obviously wrong, and we know that on the authority of, for example, Martin versus Hunters-Lessee, the federal government acts directly on states all the time. However, it acts in the form of prohibitions. You cannot do this, you cannot do that, you cannot do the other thing. The technical term for this is federal preemption. It does not act in the ordinary course of business by means of an affirmative command, and that's the crucial distinction between a prohibition and an affirmative command to do something. The Constitution contains only very, very few provisions, 3 in number, that purport to allow Congress to tell states to do something. And from the paucity of these provisions and their institutionally cabin nature, for example, having to do with election mechanisms, we infer that the general rule is you have to regulate by prohibition and not by command. Why is that distinction so important, and why is commandeering so suspect? And the answer, Justice Scalia says, has to do with the citizens' monitoring costs. A prohibition is readily observed, or rather it's for citizens, it's easy to observe whether the state is obeying or not. That's not true with affirmative commands. There'll be a lot of blame shifting. This is and evasion, and at the end of the day, when the powers are jointly exercised, nobody knows which end is up. That's very, very hard for citizens to monitor. Justice Scalia calls this an accountability principle, and for that reason, commandeering is highly suspect. So those are the original constitutional entitlements. Prohibitions are okay. That's the Supremacy Clause, no questions asked. On the other hand, commandeering is not okay. It's categorically prohibited. Can the states and the federal government, this is the next question then, can they bargain around those original entitlements? And the answer is, sure they can. Those statutes that embody such bargains are called conditional funding statutes. So you, state, accept federal funds, and in return, you will execute the following affirmative commands which we issue to you. That has to be okay because lots of things that we want to be accomplished can only be accomplished in that fashion. However, while some bargains may be good and others may be bad, a loss of accountability and rising monitoring costs for citizens are a given in any bargain. And so therefore, the Supreme Court construes these statutes under what is called the clear statement rule. The obligations that the state undertakes have to be crystal clear in the provisions of the statute itself. So you need a clear statement rule for those bargaining situations, for conditional funding programs, but not for preemption. What does any of this have to do with the Patient Protection Act? Well, take the Medicaid provisions first. That is a conditional funding statute. States provide medical services which are then co-funded by the national government. There are sort of few hints in Supreme Court precedents that say, well, maybe in some cases those statutes may be so coercive for states that they're unconstitutional. Whatever, I don't believe in that rule, but even if it's the correct rule, this particular act isn't that situation. It provides states 100% funding for benefits provided under Medicaid for new Medicaid patients going forward from, I believe, 2014 on. Whatever you want to say, can conditional funding statutes be coercive? Not if you're getting 100 cents on the dollar. So there goes that. By the way, this Medicaid challenge is technically part of the Florida case that is now on its way to the Supreme Court. We'll see what they do with it. The second part is vastly more interesting. These state-run exchanges for subsidized healthcare provision. And here's the reason why it's more interesting. What the statute says is, dear state, you shall establish an exchange to run these programs. However, if you don't, and if you can say no, but if you don't, we, the feds, will stroll into your state and establish one for you. This is called conditional preemption. There's no money changing hands in this, so it's not a fiscal bargain. How do you analyze those and understand those kinds of situations where, well, you can do it on your own and administer it on our own in accordance with our regulatory requirements, and if you fail to do so, we will do it for you. You can say that's a bargain in as much as if the state says, okay, fine, we'll do it, It gets to preserve or protect a piece of its own regulatory autonomy. That means it gets to shake down the insurers for lobbying contributions and all the rest of it. That's the bargain, the implied deal. But I think that's wrong, and here's the difference to the conditional funding situation. In the conditional funding situation, it is the case that if the state refuses the money, the statute, although you can still look it up in the US code, turns into a press release in the state. It has no legal effect for the citizens at all. That's not true in the conditional in the conditional preemption setting, where one way or the other you're going to be regulated at the end, and that's no choice at all, in my estimation. Funnily enough, or funny, the basic distinctions inherent here from that are inherent in the Constitution and contained, albeit obliquely, in United States versus Prince get you back to the mandate question. Can the federal government mandate private individuals to purchase insurance from a private carrier? The way the plaintiffs in these cases have phrased the question is, well, even if you grant that Wickett versus Filburn and all the rest of these cases earlier under the Commerce Clause were correctly decided, always in those cases the federal government regulated an activity. Here they're regulating an inactivity. You're just sitting there and your activity is you don't have insurance, and they say go buy it or else pay a penalty. And you can't do that. It seems to me the strength, this distinction between activity and inactivity has one strength and then it has one weakness. And what I'm now saying is roughly contained in Judge Sutton's opinion in the Sixth Circuit case. Look, at least the plaintiffs here are coming up with a line. I mean, we know that limited enumerated powers has to mean something. There's got to be some limit. And the plaintiffs here are saying, this is our limit, okay? And if the feds can't come up with a limit, they ought to lose. The weakness, and that in a government of enumerated limited powers, that ought to have some force. The difficulty with the argument is, it seems to me, that it seems to come ad hoc. It's from nowhere. And it's in real life very, very hard to sustain this difference between activity and inactivity. So I want to propose a different route, and this now is suggested by another opinion by Justice Scalia, and it's a concurrence in Gonzalez versus Reich dealing with the mere possession of marijuana at home for medical purposes, where he says, look, obviously the federal statute that criminalizes this conduct is not a regulation of interstate commerce. There's no commerce here, and it's most emphatically not interstate. The same is true of just sitting there and not having health insurance. However, the real question is the federal statute necessary and proper to some statute that undoubtedly does regulate interstate commerce? And that's the question, it seems to me, in the mandate case. Is this regulation the mandate, is it necessary to sustain the overall statutory scheme? Well, the federal government obviously says yes. I think that's almost certainly nonsense, but you're not going to win by running up against sort of congressional findings on this score. Proper is a totally different matter. If you go back to Prince, the reason, eventually the federal government in that case said, well, this commandeering statute is enacted pursuant to the necessary and proper clause. It's necessary, it's proper. And Justice Scalia says, no, it isn't proper. And the reason why it isn't proper is it runs up against the structure of the Constitution in a very fundamental way. And in this case, you can arguably, it seems to me, say the same thing. Even if the mandate is necessary, it isn't proper. And it isn't proper for the precisely same distinction and reason, which is that we ordinarily expect the federal government to operate on us by means of prohibitions. Don't do this, don't do that, don't do the other 15 things. We might find that obnoxious, but within those limits we can still exercise our freedom. And that is gone when the federal government orders us about. And you look, again, through the Constitution, there are very, very few provisions that seem to contemplate the federal government operating on you by means of conscription or ordering you about. The militia clauses, maybe. You can infer something like this from the jury clauses. But beyond that, it's the general expectation is we're going to be prohibited from doing stuff not ordered about. And the difference here is, second, that ordering people about is arguably part of the state's police power. But the federal government doesn't have a general police. This is why Massachusetts can have a mandate, but the feds cannot. So there's the distinction. The reason why I think this route is a little more promising than to sort of stamp your feet and say inactivity is you've got to connect that line to something in the logic of the Constitution. That's what I've just tried to do. If you want to make this argument stick, you'd have to say a whole lot more. You'd have to have half a dozen amicus briefs that go through all the permutations of the argument, over history. You'd have to tie a ribbon around it and then give it to the justices. As your appellate practice lawyer profs will tell you, you can never assume that the Supreme Court will figure it out all by itself, because it won't. But I only have 15 minutes, and I see my time is up. Thank you.
Good afternoon. It's good to be here. I want to thank Phil. I want to thank the Federal Society. I want to thank the Duke Journal of Constitutional Law and Public Policy for continuing our tradition here at Duke Law School of excellent, not just faculty programming, but programming sponsored and executed by our very capable students. It's a particular pleasure for me to be here with Michael. Michael, I consider an old friend. Whether the feeling is mutual, we'll find out by 1:20 this afternoon. We've talked about federalism together at his place in D.C., and I enjoy the ability to talk about federalism with him at my place here at Duke Law School. So I want to begin by talking about a key objective of the Patient Protected and Affordable Care Act, right? Why, among a number of different reasons, did Congress pass this law? We hear lots and lots of criticisms of various aspects of the statute, and there is a lot there to criticize, right? But I think it's important not to lose sight of why Congress and why the President thought it important to pass this piece of legislation. I then want to ask, abstracting away from the doctrinal weeds, which I enjoy as much as Michael, but nonetheless I want to abstract away from them temporarily and ask whether there's anything particularly offensive about the minimum coverage provision, which is the part of the law that is highlighted in litigation. It's the only part that some federal judges that I'm aware of have struck down. Right? The other provisions that Michael mentioned, they're involved to some extent in litigation, but there's no split of authority about their constitutionality. Is there something particularly offensive about the minimum coverage provision from the standpoint of constitutional federalism, from the standpoint of individual liberty, in light of the constitutional regime we have all been living in since the crisis of the New Deal, since 1937? Whether we like it or not, right, we've lived in this regime. Is there something different in degree or kind about the minimum coverage provision that we ought to be worried about? And then I want to say a few things about the doctrinal weeds and whether or not this provision is supported by Congress's enumerated powers. Well, why did Congress pass the Affordable Care Act? It's a very long, complicated statute. There are a number of objectives, but one key one is reducing the number of people living in the United States without health insurance. Right? The United States is the only wealthy, industrialized democracy that does not guarantee its citizens basic health insurance coverage. And so according to the U.S. Census Bureau, around 19% of the non-elderly population, or roughly 50 million people, right? So 50,000 people in this country lacked health insurance in 2009. Now, I realize it's controversial in various constitutional settings, particularly at Federalist Society gatherings, to be invoking what other countries do, right? And the fact that other countries do something, particularly, and advanced democracies in particular do something, is not by itself a reason for us to do it. But I would hope we can all agree it's not a badge of honor that we have 50 million people living in this country without access to basic health insurance coverage. We've all experienced illness, we've all experienced death. Many of us have buried a family member. Imagine going through that without basic access to health insurance coverage. This statute tries to do something about it. It's the product of a decades-long political debate that failed at various times, that succeeded at least temporarily. We'll see what the litigation brings and what the future politics brings, and trying to expand access to health insurance coverage. Part of the concern is clearly ethical. Part of the concern is also economic, right? So part of the concern about achieving nearly universal health insurance coverage is reducing the costs associated with being uninsured, and specifically the billions of dollars, roughly $50 billion of dollars of costs shifted from those who have insurance and other participants in the healthcare system, right, to those who don't, who access the system without paying for it, either because they are not able to or because they can, but they didn't get insured before they got sick or injured. So the law requires and helps American citizens and other lawful residents of this country to obtain adequate and affordable coverage. The CBO, the Congressional Budget Office, projects that the act is going to increase the number of non-elderly individuals who possess insurance by roughly 33 million by 2019. If the law operates as intended, that is a big if, particularly in light of political resistance, around 95%, not 100%, but around 95% of all legal residents will be insured. This will address the ethical concerns that many Americans have about so many people not having basic access to health insurance, right? And if this isn't the right plan, then what is the right plan to address this problem? And by also reducing the number of uninsured, it's also going to help to try and bring down the cost of health care, and specifically health care premiums. Congress determined accurately, in light of the research, that this cost shifting in 2008 was $43 billion, is passed on from providers to private insurers. They pass it on to families, and the average cost shifting per family increases premiums on average about $1,000 a year, right? So reducing significantly, although not entirely, the number of people in this country without insurance is a major objective of the law. This has ethical dimensions. It also has economic dimensions. Something has to be done, I think we all agree, to start bringing the spiraling costs of healthcare in this country under control. It was 5% of GDP, $200 billion with a B in 1960. It's projected to be 20% of GDP, $4.4 trillion with a T by 2018. There is nothing neutral about the status quo. As my colleague Barack Richmond recently said at a conference here at Duke on the Affordable Care Act, the house is on fire. Right? Something has to be done. So that's the first question I want to address. Why is this statute come to pass? Second question I want to address is whether we ought to be concerned about this in light of the regime in which we've been living in. Right? Now, if you reject the regime, you're clearly going to reject this statute. But is there something different in kind or degree about this statute given the regime we've been living in since the late 1930s, when the Supreme Court finally backed off, stopped striking down key pieces of New Deal legislation, and as Alexander Bickel once famously put it, lie down to bleed a while. And if it hadn't, that would have been the end of the story. Well, for one thing, the federal government is already pervasively involved in regulating health care and health insurance. To be sure, the states are heavily involved as well. But what has happened since the Social Security Act of 1965? It established Medicare and Medicaid benefits, and since that time, right, a lot of water under the bridge since 1965. The federal government has been the single largest provider of in the interstate health insurance market, and it's been the largest purchaser in the interstate health services market. So federal dollars during this time have accounted for more than 25% of all health spending each year since 1974. Other statutes like ERISA, the Employee Retirement Income Act, as well as a 1996 law, the Health Insurance Portability and Accountability Act, right? The federal government has come to occupy much of the field of the regulation of health benefits. It is already very much involved in the regulation of health insurance and health care. As the Supreme Court back in 1943 said, Congress could be, right? That the regulation of insurance is interstate commerce. So that's one reason to think that there isn't something particularly unusual, right, or obnoxious from the standpoint of constitutional federalism. I think there's another reason, and that is the conceded constitutionality in this litigation of other alternatives to the minimum coverage provision that would be equally or more comprehensive, more coercive, more of an invasion of the prerogatives of the states, as well as the operation of private markets, right? So instead of, it's called the individual mandate by opponents, but that's not really what it is. What it is an economic incentive, It says obtain a certain minimum level of health insurance coverage each year or pay a certain amount of money. And for most people, well, the vast majority of people subject to the requirement aren't going to be affected at all. They already have insurance from their employers or in some other way. But even for those who don't, you're talking about, after a few years after the statute goes into effect, something of the order of $700, right? In some cases, more than that, right? So we're not talking about our gargantuan penalty, right? A mandate that if you don't get insurance, right? I mean, you're talking about a relatively modest, in most cases, financial incentive to obtain private health insurance coverage, or if not, you have the choice, pay this fee that the federal government is imposing. Well, instead of doing that, Congress might have done something else. Congress might have said, we're going to give a tax credit equal to the amount of the exaction for noncompliance with the minimum coverage provision, and we're going to give this credit to everyone who has insurance, and we're going to deny this credit to everyone who doesn't have insurance. From the standpoint of the individual being regulated by the federal government, the two regimes are materially equivalent. No one who wants to be taken seriously in the federal courts is arguing that the tax credit approach is unconstitutional, right? So where are all these concerns about the federal power grab, right? Something unusually obnoxious going on here coming from? But wait, there's more, right? Because Congress could have been much more ambitious. Congress could have done what liberals in this country have wanted for decades. It could have enacted the single-payer option, Medicare for all, what Canada, what other countries use, what liberals have wanted for years, right? When the Clinton plan failed during the 90s, the minimum coverage provision was the kind of alternative that conservative Republicans had been recommending. Look back at old Heritage Foundation proposals. This is a proposal that would not just displace private markets in the states entirely. This is a proposal that would allow the operation of private insurance markets to a much greater extent than the single payer, right? So if Medicare for all is conceitedly constitutional, as it must be if Medicare is constitutional, if Medicare is not constitutional, right, well then we're not talking about the regime we've been living in, right? We're talking about a different regime. We're talking about the pre-1937 constitutional regime. Now think about this. Congress has the power to raise everybody's taxes and not only provide everyone health insurance, but determine what kind of health insurance they're going to have since Congress is providing it. That seems more offensive to federalism. That seems more offensive to individual liberty and freedom. And yet that is conceitedly constitutional. And the minimum coverage provision, which allows private markets to continue to operate, which is preferred by the insurance industry, which gives individuals choices about what kind of insurance they're going to have or not, is unconstitutional. And it's unconstitutional because of this idea of mandating, or as Michael puts it and others have put it, commandeering the people, which is prohibited for structural reasons. And I'll have something to say about that in a moment. So I think for both of these reasons, I don't think that there's something particularly offensive to federalism or individual liberty about the minimum coverage provision. In fact, I think it was very much a political compromise and accommodation to concerns about too great a federal role, to concerns about socialization, to concerns about coercion, right? And so what became a political compromise is now unconstitutional, right? And what is constitutional is now politically beyond the realm of possibility, right? So it seems like you're damned if you do, you're damned if you don't, if you want to support the cause of health care reform. All right, finally, what about the scope of Congress's enumerated powers? And here, right, we'll talk some about the doctrinal weeds. Well, as you all know, in order for Congress to win an enumerated powers case, it needs one hook, right, in Article 1, Section 8. It has to have one hook to hang its regulatory hat on. In my view, the minimum coverage provision has three, right? Three independently sufficient ways in which the minimum coverage provision is constitutional. It doesn't mean it's a good idea. It doesn't mean this whole law is a good idea, right? But as conservatives said for decades in response to what they viewed as activist liberal judicial decisions, the fact that you think a law is a really bad idea doesn't make it unconstitutional. And so I would argue with respect to the minimum coverage provision. Having three hooks to hang your hat on, that's 3/18. There are 18 clauses of Section 8. That's like 17% of Section 8. All you need is about 5%, one hook. Now, why do I say this? Well, I think the necessary and proper clause is the most straightforward way to justify the minimum coverage provision. And I do think it's interesting that Michael, unlike many other opponents of the law, doesn't see, and Judge Sutton as well, I thought wrote an opinion that is already very influential, and I think it will be before the justices. You reject the activity-inactivity distinction, but you want to articulate a different distinction between necessary and proper. Now, I think this is relatively recent, right? Necessary and proper, I think from McCulloch to Comstock, with the exception of that Scalia opinion, they were thought of, it's sort of like congruence and proportionality under Section 5. Have you seen a law that's congruent but not proportional? Right? It didn't seem like they were distinct requirements. It's broad federal power. If the end that Congress is pursuing is within Congress's enumerated powers, then Congress has wide discretion to choose the means. Well, everyone agrees in this litigation that Congress lawfully, that is constitutionally passed pursuant to the Commerce Clause, the various bans on underwriting by insurance companies, bans on denying people coverage based on pre-existing conditions, bans on discriminating based on medical history, bans on canceling insurance absent fraud, bans on lifetime limits on coverage. Right? These are very, very popular provisions. 70 or 80% of the country likes this provision. Right? Well, if that's all concededly constitutional, right, then it seems to me you need something like the minimum coverage provision as well, because what's going to happen without it? All these bans on underwriting give people an entitlement to health insurance coverage whenever they want it. So what do you think rational people are going to do? They're going to wait until they get very sick and then show up for health insurance and not be denied it. That's a great way to destroy insurance companies, right? And so it seems to me in a very straightforward way under doctrine from McCulloch to most recently in Comstock, the minimum coverage provision is necessary and proper to carrying into execution these concededly constitutional legislation passed pursuant to the Commerce Clause. I could say something about the Commerce Clause itself. I think the cost-shifting problem is a problem I've called free-running on benevolence. That itself is economic conduct. Whether or not it's activity, I agree, is irrelevant. That implicates collective action problems among the states in terms of dealing with it. How can the states deal with this problem effectively on their own? I also have a theory about the scope of the tax power, which I'll spare you for now, but I also think if you look at the material structure of the minimum coverage provision, a modest exaction that doesn't have a mens rea requirement, that doesn't increase the amount of the exaction depending on how long you go without insurance, that is not so high that people are going to be deterred from going without insurance. They have a meaningful choice. It seems to me very clear that the exaction is within the scope of the tax power as well.
Thank you both. One quick note before we jump into questions. I forgot to mention this in my intro. The Duke Journal of Constitutional Law and Public Policy is co-sponsoring the debate, and we would like to thank them for their support. Sorry, Karen. With that,
No problem. You got it.
please ask questions. Who's first? All right, I have a question. You mentioned as part of your rationale that the cost of healthcare has been exploding since the 60s, but you also mentioned that Medicare and Medicaid came into play in '65. Do you see a correlation between the government involvement in the healthcare market and the increased cost?
Well, that's an easy question to answer because you ask about a correlation, right? And so I think that I don't think who would dispute that there's a correlation, right? The government has become more involved, and the costs have gone up. Does that suggest that if the government gets out, that the costs are going to go down? I mean, one way for the cost to go down is to have people of, no or modest means to not have any kind of meaningful access to health care, right? I mean, for a long time, the federal government didn't have much of a problem balancing the budget. You had some modest impost duties for, at the time of the new Constitution and through the Civil War, right? Tax goods come from other countries, had a few excise taxes, paid off the Revolutionary War debts, no problem, right? But that wasn't a time, that was before the Great Depression, right? That wasn't a time in which Americans expected the federal government to do things like stabilize the economy, avoid depressions, like provide some basic minimum of access to health care to those who are unable to provide it for themselves. So correlation, yes. Causation, I don't know enough to know whether the remedy that one might imply, right, from what the question might be inferring is worse than the disease is, I think, another issue we ought to consider.
I'll argue for causation. When these statutes were enacted, and even for sort of 5 years, 6 years thereafter, because Medicaid grew only very slowly, the individual co-pays in the entire medical system were around 40%. We're now down to 8%, and that is very peculiar, and it depends on which segment of the market you're talking about. But if people don't have any sort of their own dollars on the table in making health decisions, yeah, the costs are going to go through the roof. And there is nothing in the statute that will prevent that. Quite the contrary, the costs will go up and up and up and up. The entire thing was financed only through sort of smoke and mirrors by yanking out $500 billion out of Medicare, which was already insolvent and is now also still insolvent, except more so by creating a class act that just was supposed to generate revenues to make the statute work for the first few years, and on and on and on and on. This thing will collapse under its own weight. And I'll say, I mean, one of the points I agree with Neil on is the mandate isn't such a big whoop at the end of the day, okay? I wish these guys good luck. I mean, Paul and Michael have been sort of friends for a long time. I wish them good luck. I'm on their side. I wish they will succeed. But in terms of will that bring the statute to a fall? No. This is not enough of a penalty. It is not enough of a financial incentive to make the statute work. If you excise it from the statute, you've done one thing. When President Obama was still candidate Obama, he agitated against an individual mandate. The person who was for the individual mandate was Secretary of State, now Hillary Clinton. So if the plaintiffs in this case succeed, conservatives and libertarians will have won the following. We've now turned the statute that the president got into the statute that he wanted. Hallelujah. Now are you happy? So that's why, I mean, this case is important, and the issue is important for a whole slew of reasons, and I'd be happy to talk about them, but it's not the key to the Patient Protection Act. Just say one last thing. The mandate, if you're worried about it because you might be among the population that might be affected by this, don't worry about it. You won't be. I've told my own kids, who are sort of a little younger than you are, and are in college, I've told them already, if this ever comes to pass, just pay the penalty and be done. No, I'm serious. I mean, if you need insurance, for really serious stuff, they're going to have the forms available in the hospital, in the ambulance. It's time enough to sign up for insurance then. Thank you very much.
And besides, if you get grievously ill or injured, don't worry. The whole healthcare infrastructure is there waiting for you. Of course, you're not going to be turned out of the emergency room, right? Other people who get insurance when they're well, right, who don't free ride on the contributions of others to effective collective action, are going to be there to bail you out.
Sorry. This statute does not remedy a free rider problem. This statute creates free rider problems left, right, and center. Go to AEI's website. There are economic, and go to Brookings' website. There are endless studies of why the free rider. You can go to the briefs now, because the economists who have looked at these things and said, well, I mean, whatever the rationale for the statute is, curbing free riding ain't gone. No, that's not it.
I do want to mention something else you voted for. You said that Paul Clement is your friend. Well, he's a better friend of mine than he is of yours.
I know that.
We actually have a cert petition together before the court in a FOIA case that I'm hoping gets granted. But anyway, I don't wish him success here. If he were still SG, he'd be arguing vigorously for the constitutionality of the minimum coverage provision, and he'd be doing it well, as he does all advocacy well. Something else you voted for, right, if this case turns out the way the plaintiffs want, is something else you voted for is a tax increase. Right, that's what you voted for. Because I agree with Michael that the court is very, very unlikely to strike down the entire statute. They're very likely to find it severable And so if you get rid of the minimum coverage provision, right, then you have two choices. You either heavily subsidize insurance companies in this country, right, or you let them fail. Because you can't have insurance companies being disarmed from being able to control their own costs, saying everyone who wants insurance gets insurance no matter how sick. We're going to take an adverse selection problem that already plagues insurance markets before the statute, and we're going to put it on steroids, and Congress won't do anything. Right? So Congress is going to have to, you're not going to be able to repeal the whole law unless you control both houses of Congress and the White House. You're not going to be able to have the whole thing struck down by the courts, so you're going to have what's the worst case scenario from the standpoint of insurance companies, which is getting rid of the minimum coverage provision, having all the bans on underwriting, and then Congress is going to be forced to act to do something to shore up the insurance companies, which one way or another, in my view, is going to turn out to be a tax increase.
I had a question for Professor Siegel related to, I guess, the rationale of this as an answer to the collective action problem. Mm-hmm. And I guess, I have sympathies to that argument, but my question would be, I guess, where do you draw the line? In the sense that many, many things be characterized as collective action. You can think about, and even in the healthcare sector, obesity, for example, creates a lot of costs on the system. So, would then be permissible to start requiring people to join weight loss programs or do other things? I guess where would we draw the line? Would that just be a political question, or right. Would the Constitution have someplace role? No,
it's a wonderful question. It's the question of constitutional limits that I'm writing about in significant part because I don't think the federal government to date has done a very good job of explaining what the limits are. The federal government has done a very capable job of explaining why, under current doctrine concerning the Commerce Clause, the Necessary and Proper Clause, and the tax power, the minimum coverage provision is within the scope of each of them. But the government did the same thing in U.S. against Lopez in 1995, in which the court, for the first time since the New Deal, struck down a federal laws beyond the scope of the Commerce Power, the Gun-Free School Zones Act. So I don't think it's a matter of just explaining and applying contemporary doctrine. It's a matter of identifying limits. In my own work, I've identified 3 that I've endorsed, 4 total potential limits on the scope of Congress's enumerated powers that the minimum coverage provision honors. One of those limits has to do with federal laws that violate individual rights. Now you might say that's cheating. We're talking about enumerated powers, we're not talking about individual rights. The problem is that many opponents, or at least certain opponents of the Affordable Care Act, including certain federal judges, repeatedly and vociferously ignore the distinction between enumerated powers and constitutional rights. And so a mandate to consume broccoli, like a mandate to take to be participating in a weight loss program, it seems to me very clearly implicates a fundamental constitutional right to bodily integrity that the courts are going to knock out very quickly, putting aside the fact that Congress is extraordinarily unlikely to enact such a law. I don't think that's sufficient, but I do think if you're really worried about what happens in the world, right, mandates are particularly controversial, right? Minimum coverage provision is very controversial. Most Americans, by a wide majority, don't like it. So the idea that we have to worry about force-feeding people broccoli, right, or requiring them to participate in weight loss programs, it seems to me to be, it's unlikely and it would clearly violate existing constitutional law protecting individual rights. There are other limits as well, right? I think Lopez and Morrison still stand, and the way I understand those cases is not about regulating activity or inactivity, it's about regulating markets or regulating other social phenomena, other social interactions. Social mandates, right, would still be beyond the scope of the Commerce Power, requiring people to purchase firearms and keep them in their homes, requiring people to possess guns in schools, right, because in the aggregate it substantially affects interstate commerce, requiring people to render assistance if they witness gender-motivated violence being perpetrated in their midst, right, to play off the facts of Morrison. Social mandates would be beyond the scope of the Commerce Power. What we're talking about is what about economic mandates or purchase mandates? And there I see 2 potential limits. I think the question of whether whether the mandate is part of a federal program that Congress reasonably concluded would ameliorate a significant collective action problem among the states. That's my proposed test. It is underdeterminate. Reasonable people are going to disagree. But I don't think it's the case that anything Congress wants to do, including requiring people to buy a GM car, right, is going to be sustained by that limit. A final limit I would mention is a comparison between what Congress did with the mandate and the regulatory alternatives available to Congress. Right? It's often going to be the case that Congress can pursue the same objectives in a less coercive kind of way. I think the minimum coverage provision, notwithstanding its unpopularity, was used by Congress because because it concluded quite reasonably, in my view, that it was the most effective way to deal with the cost-shifting problem and the problem of adverse selection of insurance market.
Yes.
This question is for Dr. I'm sorry, I forgot your last name already.
That's okay.
Apologize.
I give people wide latitude.
I'm curious, I heard you say the federal government can't do this. I'm curious to know if you think that the state governments could, and why or why not?
Barring some substantive due process limit, which I think nobody wants to go near, because you'd need Justice Scalia's vote, certainly in this litigation. Yeah, I think states may do this. I think there's no problem with, I mean, at least not from the vantage of constitutional structure, with states requiring their citizens to purchase health insurance.
That's been Mitt Romney's view throughout.
Could one or both of you talk about the necessary and proper clause and using the proper as a separate from, I thought both of them were pretty much interpreted together, but using it to go ahead and look at the 10th Amendment and look at the rest of the Constitution, which could swallow up the necessary proper clause and the powers, enumerated powers. If you're looking at what's proper, how do you define that?
That's going to be quite an involved argument, right? And what's not going to work is, I'm going to suck my thumb and say, that was just disgusting, that's over the line, right? Then it really looks like substantive due process gone bonkers. That doesn't work. The way you want to run the argument, it seems to me, is the way Justice Scalia runs it in Prince. That is to say, the structural argument comes first. And if then somebody says, well, you know, necessary and proper, oh, no. Proper is shorthand for the constitutional structure. And I would cite, there are a lot of, Neil is right. I mean, this hasn't come up very often. But you can sort of mobilize a lot of language in decisions. McCulloch versus Maryland, you know, for starters, for the proposition that something like this has to be right. Just because you have the enumerated power doesn't mean you can do it in any way, shape, or form you see fit. New York versus United States stands for the same general proposition. Again, that's kind of the spade work that somebody who wanted to pursue this argument in this particular case would have to make. I haven't come within shouting distance of, you know, persuading anybody who's like, well, no, wait a minute, I mean, you know, I'm skeptical about it. But the general gist of the argument, it seems to me, has got to be right.
I appreciate the question because it gives me an opportunity to respond to this part of Michael's opening presentation as well as what you just said now. It seems to me that this part of the argument has to be wrong. And the reason I say that is because I understand New York and Prince, or as I like to call it in first-year common law, the case formerly known as Prince. I understand it differently, right? To me, the distinction is not between prohibitions and affirmative obligations, among other reasons because it's very easy to recharacterize one as the other, and also because there are, in fact, lots and lots of federal laws that require people to do stuff. It's not just jury service, it's not just the militia, it's the draft, it's filing a tax return, it's paying the taxes, it's surrendering property when Congress exercises the power of eminent domain, it's cleaning up environmental spills on your own property even if you didn't cause the damage, it's federal child support payments. I mean, there are lots of affirmative obligations. There are reporting requirements and lots of federal laws. So these are all obligations, most of which are conceivably constitutional. But I think it's more fundamental than that. And I promise I'm not filibustering, you'll get a chance. I don't think the distinction is between prohibitions and obligations. I think it's the distinction between the federal government treating the states as regulated entities, like it regulates individuals, which is permissible, and the federal government requiring the states to regulate private entities. It's whether it treats the states as regulated or as regulators, as puppets for a ventriloquist Congress, the way Justice Scalia put it. I don't think that distinction has traction at all when it comes to commandeering individuals. Individuals are being regulated by the federal government one way or the other. The question is, in which way are they going to be regulated? And so the idea that the more invasive way of regulating them using the tax power is okay, but the less invasive, less coercive way through a minimum coverage provision is not okay because it offends the constitutional structure, seems to me, to get things backwards.
I would disagree. I would stick with I think the distinction between prohibition and affirmative command is elementary. I think it's not very easily overrun. Just try to rephrase Medicaid as a series of prohibitions. It cannot be done. I think the distinction that I've tried to outline is very well established in 19th century cases. I believe it is also sort of, if you look at the cases carefully that deal with private behavior, there are cases that go to this. So first of all, most of the affirmative obligations Neil mentioned are predicated on doing something first. If you don't have, so you yourself entered into this relation. In the cases where it isn't the case, if you read the conscription cases, they all read that, this is really out of the ordinary. We're very, very, very nervous about this, even in a military context. And so don't do this, unless you absolutely have to. The final cases, and I know this will be incendiary. I don't mean it to be, but I can't help myself. The cases that I would cite for the importance of this distinction between prohibition and affirmative command with respect to private behavior are the Japanese internment cases. The first round of cases dealt with a curfew, which was a mere prohibition. Don't go out after curfew. Korematsu itself dealt with an affirmative command. You show up at the point where you're supposed to show up. And that is a lot more problematic than the mere curfew. Put aside the racial classification in the cases themselves. And if you look at the opinions in those cases, at least some of the justices understood that that was a real distinction, and so I believe it is here.
2 quick points. The first is, it sounds very much like you're making the activity-inactivity distinction, right? That you said that you rejected. Are you doing something or are you doing nothing? The second is, imagine you had the spread of a flu pandemic across state lines, because flu pandemics disrespect state borders. Imagine Congress, pursuant to the Commerce Clause, requires people in affected areas to get vaccinated. Is there any doubt the Supreme Court of the United States would uphold such a law? Is there any doubt that it ought to?
The answer is no. Wait a minute. The Supreme Court has upheld a ton of stuff. No, just kidding. Look, with respect to the activity, this is why I said at the beginning, you've got to connect this to the constitutional structure in some way. There is something real there, but if you just sucked your thumb and said, well, that's a line, and it's the line that sort of says, all those cases are okay, but this is over the line, that ain't good enough. What I've tried to do is try to reconnect this to the constitutional structure in a way that might have some bite. And as for the epidemic example, I would say, it's the same as sort of military emergencies. It's one thing to say there are that there are emergencies and there are things that are necessary for the federal government's intrinsic functions. It's a totally different thing to say we guarantee the operation, of private health insurers who pay our campaign contributions.
So Congress can prohibit thumb sucking, but it can't require it.
Produced by Duke University. Online at duke.edu.